Good morning, Mr. Maiden.
Good morning. Please the court. My name is Stephen Maidman. I represent Antoine Burton, the defendant in this case. Your Honors, in this case, the defendant was indicted for armed home invasion for a crime that allegedly occurred on October 24th, 1999. At that time, the home invasion statute, in effect, was the amended version of the statute that went into effect in 1998.
If we agree with you, why shouldn't we just reduce this to second-degree murder? Why is a new trial necessary here?
Your Honor, a new trial is necessary in this case because there was prosecutorial misconduct.
For reasons beyond, well,
Not
in
related
connection
to
with the charge, in connection with the charging decision? In connection with the charging decision, or no?
Not,
I mean, having nothing to do with the fact that you claim that the armed assault with intent to murder statute or armed home invasion statute doesn't qualify as a life felony. So separate and apart from that.
it's separate and apart from that.
Okay.
But this was a.
But if we agree with you, so if just, I want to be clear, if we agree with you solely on your argument about the statute not being a life felony, then you agree that what we should do is reduce the verdict to second degree.
No, I would argue that it should be.
On that point.
In other words, if we don't agree
with your, if we don't agree with your other arguments, we agree with you only on your argument, excuse me, about this statute not being a life felony, then is the proper remedy second degree?
I don't believe that's the proper remedy.
Why?
Because there was prosecutorial misconduct.
Now, you're not answering my. You're not listening to my question.
No,
I said we don't agree. If we do not agree with you on your other issues, if we say everything in the rest of the trial is fine, it was a perfect trial, there were no other errors, do you agree that the remedy is second degree? We're agreeing with you only on your statutory argument.
I understand that.
Then do you agree that the remedy is second degree?
No.
Why not?
Is the prosecutorial misconduct that you're referring to related to the charging under this statute?
I thought, well.
No, he was indicted for first-degree murder.
Right.
And there was only one predicate felony that was alleged, which was home invasion.
Well, I thought there was an attempted armed robbery.
No, he was not indicted for attempted armed robbery.
Is there any other prosecutorial misconduct that you're arguing? I mean, did he make a bad final argument? Did he introduce improper? Well, then the only thing is what's just been suggested, that you say the prosecutor knowingly, I guess, said we'll use armed home invasion.
Which he was entitled to do. He could have, even though he wasn't
Simply
indicted.
made a mistake. They made a mistake.
No, this is more than, I think
the legislature made a mistake too, but you may benefit from it.
Well, you obviously have the discretion. It could be second-degree murder. It could be a new trial under 33.
Well, it could be.
It could be either one of those two.
But the jury clearly found him guilty of first degree, so there's no question that they found him guilty of the home invasion. So second degree would appear to be the remedy, unless the Commonwealth persuades us to one of their theories on why we should sort of interpret the statute some other way.
Mr. Maidman, may I ask you this? Do you know, or is there any statutory history, or maybe not narrowly defined, why or what cause triggered the change back in 2004?
No, I don't know about 2004.
I think I've got the correct.
No, you do.
Yeah.
You do. I went to the archives.
Okay.
I went to the archives on a previous case involving the home invasion statute. One of the things I discovered that.
Well, was the change after our decision, Commonwealth versus Brown?
Yes, it was after that one, and it was after the.
Commonwealth versus Burton as well.
Right. The change was in 2004. Brown was decided in 2000, and Berthet was 2003. And
I think, well, we indicated a problem with the statute.
There is a problem with the statute.
And so maybe that's why they did it. Can I ask you a question? Go ahead. I'm sorry.
You said you went to the archives, and?
It is very hard, at least in this, there is no legislative history as one would expect when one looks at a federal statute. It's not like there were hearings. I actually tried to do it for another case, for this statute, and I couldn't find anything. I've given up on legislative history on these types of things.
Well, fortunately, our law clerks don't. They
I
manage.
think I would expect they're going to find the same thing as me when they get there.
No, it is. It's not the same as the federal congressional record, where things can get put in and taken out. And
right. It's inherently, as Justice Cowan wrote in 2000. I think she wrote inherently nonsensical, and I agree with that.
May I just ask you a follow-up question? If, which is really what I was leading to, if that statute was changed in 2004, likely in response to some of our decisions, can one then say that attribute to a prosecutor prosecutorial misconduct when apparently up until that time, until we closely examined the statute, nobody seemed to think or recognize what the problem was?
Justice Marshall, I'm not sure which case you're referring to, because the only cases that I know where this was directly addressed was the 2000 Brown decision and the 2003 Berthet decision.
Right.
And then there is one other case in the appeals court where a sentence was reversed, and there's actually an unreported decision as well. But
there was an appeals court decision called Commonwealth versus Brown, because that was the case in which we granted further appellate review, and that was the case. So there's that decision out there, too, which was not in accord with our decision, our Brown decision.
My recollection,
No, I know that. I wrote Brown, so I can tell you that we didn't agree with the appeals court in Brown.
Well, one thing I did notice that there was in the Berthet decision, to the extent it's relevant, further appellate review was denied and the defendant brought it.
But can I ask you a question? I just don't remember. Who was we had another defendant in this murder. Who was that? Which other one?
There are two. There are
the facts.
Actually two,
I knew we had gone through it before.
The name is it's the shooter.
Taylor.
That was Taylor.
That was Taylor we've had before.
And then another one pled out.
Okay.
So your case is simple. We've just discussed it. There's the statute read the way it did when your man was indicted and tried. It wasn't a life felony. Ergo, it's got to be murder 2, or if we decide under 33E that we ought to do a new trial, then I assume the new trial would be for murder 2. Or do we go back and try him again for murder 1?
He tried for murder 1. I don't know how you would do that without a double jeopardy bar. But the other case, it's in my brief, is Commonwealth versus Kronk. And that case does say that
well, they didn't acquit him on murder 1.
In Commonwealth Kronk, that's right.
No, I mean in this case.
No,
where's
they
the
just
double jeopardy?
They convicted him of a crime which was based on a predicate felony that was ineligible for first-degree felony murder. It's an extraordinary case.
But why is that different for purposes of retrial than, and I'm asking this, than if a defendant is convicted with a statement that's been improperly admitted under Miranda, and we rule on appeal that it shouldn't have come in, and then he goes back for retrial on murder number 1 without the statement?
Justice Collin, the only way I can address that is the prosecutorial misconduct argument. And the one thing I would also, one thing the court might consider is if Rule 3.3 of the Massachusetts Rules of Professional Conduct is going to have any teeth. The Commonwealth
that statute was so difficult to understand. I mean, I wrestled and wrestled and wrestled with it.
I think the short answer really is that he couldn't be retried for murder 1 because the operative law when the act occurred didn't make this a life felony. So you can't go by a subsequent statute. I mean, that would be not necessarily double jeopardy, but it's kind of
it would be too late to charge under any
ex post facto punishment.
Would you say that too? In other words, it would be too late for the prosecutor to charge
armed robbery or something.
No, armed robbery or under premeditation or something other than felony murder.
Well, I'd have to defer to my brother for what people can be charged for, but the bottom line is that as far as armed robbery is concerned, you'll see that I included in my record appendix the verdict slip, and it's very clear that this was presented to the jury, and the jury did not find him guilty of armed robbery, and so it would seem to me that would be barred as well.
Did they check something off?
Oh, yes, it's in my record appendix.
And it's not guilty?
The way it was set up, it's not that clear. The way it was set up
is one of these they didn't check the box thing. They checked the home invasion.
That's right. And they also...
Not the other one.
That's right.
Well, that's not so good, is it?
Not so good for the Commonwealth.
Not so good for what they did, either. We don't know what they did. They could have well said, we don't need this other one.
One would have to look at the instructions, though. I assume that the instructions were, if you find him guilty of both, you check both.
I don't remember that, but one thing was very clear was one thing that I do remember is the judgment was very explicit that home invasion is a life felony, and there were not second-degree felony murder instructions given to the jury as well.
Were not given.
That's right.
Okay.
The only, in the event of a retrial, the other issue that I'd like to just briefly address is the co-conspirator exception to the hearsay rule. The Massachusetts law is well developed on the first. There are two prongs. First prong being that the statement has to be made during the pendency of the joint venture or conspiracy. The second prong being it has to be made in furtherance of the.
How close in time was the conversation between Taylor and Cooper, and then the hiding of the the gun in the mattress?
It's unclear in the record. Not a footnote addressing that. It was not. It is unclear. That's the best I can say. And you'll see in the footnote. I believe it's in my reply brief. You'll see that the citation says transfer, but the bottom line is that you cannot tell.
Okay.
But just to wrap up, the in furtherance prong has never been developed under Massachusetts law, and I don't see how. What kind of argument can be made that the statements were in furtherance of the conspiracy, even assuming that it was during the pendency of the conspiracy? And the Massachusetts law is not well.
Well, it would be because if it were during the pendency, then I don't remember who yelled at who, but one of them, Cooper was yelling at Taylor, "Why'd you do that during our joint venture?" And it's still a joint venture. There's still And then he hides the gun in the mattress. That was in furtherance of the joint venture to prevent it from being discovered. The gun, which he shouldn't have used, is then hidden in the mattress.
I don't believe you can. That's not clear in the record. That would be the answer to that question.
No, that's
it could have been. It could have been. I can't answer the question because it's not clear.
Mr. Maven, are you saying, put aside the problem with the statute? I thought your argument was that this, or in combination with the other errors that you have, you would say independent of the statute would require a new trial, or are you not saying that?
I did not expressly. Certainly, I guess, was implied by my brief. Independently, I would say that this testimony, the statements were very prejudicial. I don't think there's any question about that. This was the only testimony from a percipient witness of the shooting. And it shouldn't be, and it should not have been admitted. So I would argue that, and there, I don't recall whether there was an objection. I don't believe so. I just don't remember at this point.
And the defendant wasn't present during this conversation, or was he?
Well, to the extent that you can assume he was in the apartment, he was present.
You say no other testimony, direct testimony, but there's all this testimony that the group went in and then the group came out together.
Part of the group. One carload went in, and actually they did not all leave. Taylor left separately. He left. I believe he. I believe it's in my factual presentation. I believe he left before, or I know he left separately. He did not leave with the other two. The defendant and Cooper left together with Natasha Nelson.
But there was a lot of, besides that the carload went in, there was witnesses who heard shots, weren't there?
Yes. Yes, there were multiple witnesses that heard shots. There was Mr. Rich, who lived upstairs, and there was, definitely him. He testified to fireworks.
So
then there were shots fired outside as well.
So independent of the statement, I think this is Justice Cowen's question, independent of the statement, you've got going in and you've got shots.
You have leaving the car.
And you have a dead person.
And then you have coming out, because a lot of people saw him coming out.
Well, they never saw the defendant. No one ever identified the defendant coming out.
But then he's back in the apartment. He came out.
Assuming he went into the apartment. And there's no testimony that the defendant was in the apartment.
Well, Nelson testified. Nelson's the one in the car, right?
Yes.
She testifies that the four of them got out to go to this place to buy drugs, and then they came running back and jumped in the car and took off.
Correct.
After the pop,
That's
pop,
correct.
pop, pop, pop.
That's correct.
And they were seen coming out of the building, these four people.
3 or 4. It's a little bit unclear on that.
I thought Seltzer testified that there were 4. I thought Seltzer testified that there were 4 people.
I think he said. I think he equivocated on that. It's either 3 or 4.
Okay.
It's not. I don't believe it's perfectly clear.
You also have your client's confession or admission.
Yes.
Okay. You say that should have been suppressed because
I
it was
say it
involuntary.
should have been suppressed as involuntary, and I also say that I would suggest to this court that it's time to address whether all custodial interrogations should be recorded as a matter of constitution. Videotape would be even better.
We've already made one step in that direction, and this case was long before this case was tried, wasn't it? Long before DG and Batista, or was it tried afterwards?
Before.
Well,
Trial was in 2005.
Oh, so the incident occurred in 1999.
I don't believe this. I think this is a pre-DG Batista case.
Well, I'm saying, I guess I meant that the recording is long, or that the failure to record is long before the G. Batista.
I think that's a fair statement. That's true. That's true. But as I indicated in my brief, there's no case in America that I'm aware of where that's ever been held that there's a constitutional obligation to tape record an interrogation. On the other hand, of the Massachusetts Declaration of Rights, the Fifth Amendment protections are treated treated better, more extensively than under the federal Constitution.
And did I read this correctly that your client actually got the benefit of the DG and Batista instruction?
I think so. Yes, he did.
Mr. Maidman, I only suggest that if and when all confessions, admissions, and interrogations are videotaped, the defense bar may come to regret it.
And I would tend to agree with that. I would tend to agree with that. On the other hand,
I should say, in fairness to the defense bar, like the prosecutors, are interested in truth, no doubt, but it is highly persuasive evidence.
I think there will be more guilty pleas when everything is tape recorded. On the other hand, at the margins, where cases where things are disputed on what is said, disputed on the mental capacity of the defendant, disputes over who initialed the Miranda form, everything else, I think things will get a lot clearer.
I think that was the import of Justice Sussman's excellent opinion in DG and Batista.
Well, the only other thing I would suggest is that other jurisdictions are moving forward in that direction. But again, in my argument, I made a constitutional argument, not a general superintendent's argument. And unless the court has any further questions, I would rest on my brief.
Thank you, Mr. Maidman.
Thank you.
Mr. Bladley. Morning.
Good morning. May it please the Court, John Bradley for the Commonwealth. I was also trial counsel for the Commonwealth in this case. And I'm asking this Court to affirm the defendant's conviction for murder in the first degree based solely on the theory of felony murder. Just to clarify a couple of issues that cropped up during defense counsel's argument, there were 2 underlying felonies submitted to the jury, and there were 2 underlying felonies on the verdict slip. One obviously was armed home invasion. The other was attempted armed robbery. The jury simply checked the box of guilty under a theory of armed home invasion. They didn't check the attempted armed robbery box, and there was no not guilty option next to either box.
But the indictment was for armed home invasion.
That's correct.
There was no indictment for attempted robbery.
That's correct.
But did the judge charge that if the jury found that Commonwealth had proved both of them, they should check both?
She did. She did. But if I'm not mistaken, and I'm not sure what relevance it may have, but if I'm not mistaken, that's exactly what happened in Carlino, the opinion that this Court issued several months ago. And in Carlino, this court said that, notwithstanding the fact that the judge gave the instruction, there could be a new trial. There was no double jeopardy problem because you simply didn't know what the jury thought about the other felony because they didn't check the box.
Why don't we tackle the sort of the tough question first, or a tough question first, and that is, if we agree with the defendant that the statute for armed home invasion won't support this verdict, what is the remedy? Is it reduction to murder 2, or do you see an opportunity for this man to be reindicted for murder 1 on another felony, like our attempted armed robbery? What would the Commonwealth argue for?
Well,
keeping in mind that I prefaced all this with, if we accept his argument.
I understand, Your Honor. I think it's a reduction to murder 2. I guess it kind of ties into my other argument on Carlino. I think under Carlino, he can be retried for first-degree murder on a felony murder theory, with the underlying felony being attempted armed robbery.
What does the Commonwealth want? Or what do you prefer? Or do you want to think about it and let us know?
That would be my preference, Your Honor. If I had to answer right now, I'd say my inclination would be to accept the murder 2, but I would ask for some time to think about it should the court decide to go that route.
Mr. Bradley, let me suggest, would you let us know one way or the other? In other words, think about it and then just send us a letter,
sure,
one way or the other.
Sure.
And Justice Cowan is asking me to give you a date, and if you could say, how much time would you like? Don't say 6 months.
Oh, a couple of weeks is fine.
Can you do it by the end of next week?
Sure.
Judge Mellon, Clerk Mellon, would you figure out what that date is? And if you would like to respond, Mr. Mayman, you have 7 days in which to respond.
Now, just to have a little bit of background here, this other defendant, Kenneth Taylor, who was mixed up in this thing, was he mixed up in this thing?
Yes, Kenneth Taylor was the shooter. He was tried initially, and there was a hung jury in the case. The case worked its way up here on the double jeopardy claim. This court issued an opinion authorizing the Commonwealth to try Mr. Taylor again, finding that there was no double jeopardy problem. The evidence was sufficient to support a conviction at the first trial. Mr. Taylor was subsequently tried again and convicted of murder in the first degree.
Is his case working its way up?
His case will be up here eventually, Your
And the
Honor.
same problem exists in that?
No, because in that case, the jury was also given the option to find him guilty on a theory of deliberate premeditation.
And they so found?
They so found.
Okay.
In this case, your argument is you don't need we should do something with the statute that gets you to preserve the first-degree murder conviction?
Generally speaking, that's my argument, Your Honor. That what I'm hanging my hat on is the opinion in Commonwealth versus, I don't know how you pronounce it, either Marone or Maroney in 387 Mass, which presented a similar issue. In that case, the crime in question was trafficking in heroin, and the statute, as it applied to 200 grams of heroin or more, called for a determinate sentence of 15 years. And there was also general language in the statute that there was a minimum penalty of 3 years, a maximum penalty of 15 years.
Isn't that the difference right there? I mean, what you want us to do is strike out this part and go to where it says life felony, right?
Go from the minimum and, yeah, concentrate on the language that calls for a minimum and a maximum sentence, which is the way it's supposed to read.
But I mean, in the Maroney case, the alternative was in favor of the defendant. Here, it is distinctly not in favor of the defendant. So if you take the rule of lenity about interpreting statutes, how do we get there?
Well, I don't think the rule of lenity ought to apply, Your Honor. My argument is that you have Maroney, and as I recall, I don't think this court focused on the rule of lenity in Maroney. They simply found that the language of the statute calling for a determinate penalty conflicted with 279-24.
Well, that created an ambiguity, and the statute was then interpreted in favor of the defendant. But the sentence in Maroney was totally screwed up because he was sentenced to serve from 15 to 20 years, which was beyond the maximum in the statute.
Right. And, you know, I don't think judges know what to do when they see that determinant penalty language, so they do what they typically do. They impose a minimum and a maximum. But here, the other part of my argument, and I think it makes our case here a little bit stronger for the position.
Actually, Maroney zeroes right in on this. The vice in all the Commonwealth's arguments is that they require us to resolve an ambiguity in a criminal statute in the favor of the Commonwealth. We don't do that. So Maroney did. That was not an unimportant principle in Maroney.
The other thing I'm focusing on is the legislative intent. The legislature clearly screwed this up. They managed to...
I can't chastise you for the use of that word because my colleague has just used it, but let the record reflect. If we could go back to plain English, that won't send all the school children who are watching these arguments...
They made a mistake.
Thank you.
To speak euphemistically, Your Honor. They managed to reach the exact opposite result of what they clearly intended. 1998 was the Get Tough on Guns year. They promulgated the Gun Control Act that year. And the intent clearly, I would submit, was to fix a minimum penalty here of 20 years. It was supposed to be a 20-year to life penalty. In some way, somehow, they managed to reach the exact opposite result of that.
Well, is it possible to construe the sentence that causes all the trouble, the 20-year sentence, as surplusage? Doesn't the preceding sentence, unless I'm reading this wrong, say that if, I'm paraphrasing now, if you commit an armed home invasion, armed with a dangerous weapon, you should be punished for life or any term of years not less than 20 years?
Right.
And then, of course, we got the sentence that causes the trouble. If they've already said life or not more than less than 20 years, this sentence really becomes surplusage, doesn't it?
Well, that was the language, unfortunately, that was specifically inserted at the time, correct? In other words, as I understand, the 1998 statute started with whoever commits said crime while being armed with and then goes on said sentence all the way down to the 17 years of age. That's what came in, as I understand it.
That's right. That's right.
So if they had just left it, there wasn't a problem, right?
That's right.
Okay.
And I didn't use the word surplusage in my brief, Your Honor, but I did point that out. And the fact of the matter is it's still a life felony. You know, it's still a felony that qualifies for first-degree murder under the felony murder rule. The problem area, obviously, is this sentence or two in which the legislature...
It's one sentence is what it is.
Actually, two sentences.
Two?
It's the second sentence that was also added. Said sentence shall not be reduced to less than 10 years. That was also added in 1988. So it says
that would make sense because if he's sentenced for, let's see, a term of not less than 20 years, well, all right, yeah, okay. Yeah, I do see a problem there. Not less.
So both of those sentences were added actually in tandem in the 1998.
That second sentence causes a little trouble also.
What they did was they made it a lesser crime if you commit an armed home invasion with a gun as opposed to a baseball bat, a knife, or any other weapon. It truly just doesn't make any sense whatsoever.
It doesn't make any sense, viewed one way, why they even amended it. Because
I don't see how you can say surplusage. It just won't work.
But I do think, Your Honor, using Maroney as a paradigm, you have the authority to excise that language from the statute. And I also pointed out Chapter 4, Section 6 of our general laws in support of that argument, too. It allows you to remove that sentence or two from the statute because it doesn't make sense. It clearly was not the intent of the legislature to have a result like this one, and that's what I'm asking the court to do.
Yeah, we couldn't construe that. It would be hard to construe that as surplusage now because in Brown we said that it established a mandatory minimum sentence of 20 years. So defendants convicted of home invasion could receive sentences ranging from minimum of 20 years imprisonment to maximum of life.
And I think that's what they intended when one commits an armed home invasion with a gun. But as you also pointed out in Brown, Your Honor, under the truth in sentencing laws, the 10-year minimum doesn't make any sense. It has no practical application at all.
That's right.
So the whole thing was
What's interesting, too, is how they fixed it.
They went back to square one, basically.
Yes, exactly. If they'd simply put the words "at least" in what they did, they would have made it.
And unfortunately, we had this 6-year window of time where we had this...
the most serious invasions.
The most serious of all
which are
carried
most
a lesser
likely
penalty.
to result in the loss of life.
Right. In fact, it wasn't until, I think, 4 years or almost 4 years after Brown that they actually got around to fixing the problem that they had created. And I don't know how many cases worked their way up here with that issue as a result. But in any event, my main argument is that you do have the authority to remove that language from the statute. It's absurd language. It makes no sense. It wasn't the intent of the legislature. They simply made a mistake. And that's what I would ask this Court to do. I would like to address the issue that's been raised by appellate counsel of prosecutorial misconduct, since I'm the one that's up here being accused of it, Your Honor.
He's talking in terms of bringing the indictment, I think.
Well, that's not what I got out of it, Your Honor, respectfully.
Really? What did you get out of it?
I get out of it that I'm the one in the line of fire and that I kind of laid behind the log during the trial of this case. Somehow he concluded that I knew that this was improper and inappropriate, yet I chose to remain silent. And it wasn't until the issue was raised by the clerk right before closing arguments when it came to light, so to speak. In a perfect world, I would know everything and would never make a mistake. But I'll tell this Court I'm not going to beat myself up over this one too badly. I was the third prosecutor assigned on this case. I got assigned the case in late 2003, and when I got the case, it was in a trial posture. And as any trial lawyer would understand, when you get a case that's ready for trial, your first order of business is marshaling the evidence and the witnesses. Eventually, you focus on your theories of guilt, and by the time I read the statute, it had been amended.
Yeah,
so,
I don't think any allegation of quote misconduct can be made on this record. So.
Well, I would hope not, Your Honor. I think they've almost become standard fare in this business today, and I take them very seriously.
The whole thing was just a mistake.
Well, I hope so.
I just reread Brown, and if in Brown we said, I think it was this version of the statute. Wasn't it the same version of the statute we were dealing with?
Yes. No. Okay. Well, actually, we were applying the pre-98 version.
You're right.
And we commented about the 1998 amendment.
Commented in Brown about the 1998 amendment.
Oh, okay.
And said it imposes. We said it imposes a significantly lesser sentence on what is intuitively a more serious crime.
Okay, that answers that.
Just touching briefly on the issue of the statements made at the apartment after the murder, I would draw the Court's attention to the case of Commonwealth versus Wright in 444 Mass. I would suggest that the facts are very similar. The specific language I would rely on is that the defendants here were sharing information. This was a situation where, by the defendant's own admission, they intended to commit a robbery here. Mr. Taylor got trigger happy and deviated from the script when he saw the victim with a telephone in his hand. He then proceeded to shoot the victim 3 times. That enraged Mr. Cooper back at the apartment. He wanted an explanation for why Taylor did what he did. And just like in the Wright case, the defendants were sharing information. The joint venture was clearly still ongoing. In fact, it went on until a couple weeks later when Mr. Burton bumped into Ms. Nelson in the street and indicated that I believe it was Ms. Daniels, whose apartment it was still talking and that someone needed to take care of her. And unless the Court has any questions on the remaining issues, I would rely upon my brief.
Was Mr. Cooper, what happened to him?
The answer to that question isn't contained in the record, Your Honor. I'll be happy to answer it for you anyway.
I think we
Did he plead guilty to manslaughter?
He pled guilty to manslaughter, according to the note I have.
He did. He did, and that offer was made to Mr. Burton as well. Mr. Cooper accepted the Commonwealth's offer and ultimately testified against Mr. Taylor. Mr. Burton declined it.
Okay.
Mr. Bradley, we often upgrade counsel for not including the statutes and so on. I'd like to thank counsel, both of you, for giving us very complete records here so we could actually make our way through this. So thank you for that.
Thank you, Your Honor.